Now in this video we will discuss from order 2 of the Civil Procedure Code, that is frame of suit. In the previous video we have discussed in detail, or rather read in detail, the order 1, and now starting from order 2, that is frame of suit. Order 1, rule 1, frame of suit. Rule 1 of order 2 says every suit shall as far as practicable be framed so as to afford ground for final decision upon the subjects in dispute and to prevent further litigation concerning them. So, frame of suit, order 2 rule 1 simply says that suits must be framed in such a manner that multiplicity of proceeding as much as practicable must be avoided. So, every suit shall as far as practicable be framed so as to afford ground of final decision upon the subject in dispute and to prevent further litigation concerning them. Now, rule 2 says suit to include the whole claim. Now, this order 2 rule 2 simply says that splitting of claim is not expected and permissible. It says that every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but a plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. So, it is the general duty of the plaintiff to raise whole of the claim which the plaintiff is entitled to make in respect of the cause of action. But a plaintiff may relinquish any portion of his claim. He has the discretion, the plaintiff has the discretion to relinquish any portion of the claim to bring the suit within the jurisdiction of any particular court. But in that case, there is a consequence. If we relinquish a claim, there is a consequence. Now, what is the consequence? Now, order 2 rule 2 sub rule 2 says relinquishment of part of claim. Where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. So, once a plaintiff either by mistake or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Now, sub-rule 3 says omission to sue for one of several reliefs. Now, a person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs. But if he omits, except with the leave of the court, to sue for all such reliefs, he shall not afterwards sue for any of the reliefs so omitted. So, sub-rule 3 deals with omission of the plaintiff to sue where he is entitled to several reliefs and he omitted in respect of one of the reliefs. So, a person entitled to more than one of the relief in respect of the same cause of action may sue for all or any of the reliefs. If he intentionally omits or relinquishes any part of his claim, that's another thing. But if he omits to mention any part of the claim or relief to be claimed, now in this case he will not be entitled to bring a separate suit on the same cause of action. Okay, the action may sue for all or any of the relief, but if he omits except with the leave of the court. Now in this case, rule 3 gives the plaintiff an option to ask for the honorable court's permission. If the court permits that part of the claim must be dealt with in a separate suit, that's another thing. But if he doesn't ask to the court for any leave, then he shall not afterwards sue for any relief so omitted. Now explanation. In this case, explanation says, for the purpose of this rule, an obligation and a collateral security for its performance and successive claims arising under the same obligation shall be deemed respectively to constitute but one cause of action. So, for the purpose of this rule, now this rule means the whole of the claim. What it is talking about, that plaintiff must raise whole of the claim. The splitting of claim is not permissible. This concept, for the purpose of this rule, an obligation and a collateral security for its performance and successive claims arising under the same obligation shall be deemed respectively to constitute but one cause of action. Okay. So, it will be a single cause of action. Now, illustration A lets a house to be at a yearly rent of rupees 1200. A lets a house to be at rupees 1200 per year. The rent for the whole of the year 1905, 1906 and 1907 is due and unpaid. A sues B in 1908 only for the rent due for 1906. A shall not afterwards sue B for the rent due for 1905 and 1907, because he relinquishes or omits to bring his whole claim in that suit. Now, in this case, if A satisfies, after satisfying the court that he have reasons and those are valid reasons to not raise that claims in that suit in which he claims the rent due for the 1906, and if the honorable court is satisfied that the rent of 1905 and 1907 must be claimed in a separate suit, then he can raise or bring a separate suit. Otherwise, he will not be entitled to entitled to bring a fresh suit for the claims of 1905 and 1907, which he relinquishes. Now, we are ignoring the state amendments. Now, this is sub rule 3 of rule 2. Now, order 2 rule 3 says joinder of cause of action. Now, what is joinder of cause of action? Cause of action, what is cause of action? Cause of action means the ultimate point at which the parties are at variance or at difference. That is the ultimate point on which one party claiming that it exists and another party is denying that it does not exist. Now, if this is the cause of action, then in a suit there are several points which can be raised in a single suit to be a cause of action. Now, in this case, in this rule, we are talking about this joinder of cause of action. Save as otherwise provided, a plaintiff may unite in the same suit several cause of action against the same defendant or the same defendants jointly, and any plaintiffs having cause of action in which they are jointly interested against the same defendant or the same defendants jointly may unite such causes of actions in the same suit. So this rules, rule 3 of order 2 say, rule 3 sub rule 1 of order 2 says that the plaintiff may unite all of his cause of action if it is against one person, or he may unite all the cause of action if the defendants are several defendants but they are jointly liable, and the plaintiff having cause of action in which they are jointly interested. Now, this is the vice versa. This is the opposite setting. In this case, there are several plaintiffs. In a previous sentence, we are dealing about one defendant and several defendants liable jointly. Now, in this case, there are single plaintiff and several plaintiffs interested jointly. Okay. Now, interested jointly against the same defendant, or there may be several defendants also. Now, in any scenario, the same defendants jointly may unite such cause of action in the same suit. Okay. Now, sub rule 2 says where cause of action are united, the jurisdiction of the court as regards the suit shall depend on the amount and the value of the aggregate subject matter at the date of the institution of the suit. Now, if the cause of action and the parties are added, the cause of action is several cause of action is joined in a one suit, then for the purpose of the jurisdiction of the court, the value of the suit shall be decided on the basis of what? On the basis of value of the aggregate subject matter at the date of the institution of the suit. Okay. Now, rule 4 says only certain claims to be joined for recovery of immovable property. Now, in case of immovable property, only certain claims, those claims which are not uncertain, which are specified, these claims can be joined for the purpose of recovery of immovable property. Now, no cause of action shall, unless with the leave of the court, be joined with a suit to recovery of immovable property, but there are some exceptions. What are the exceptions? The exception says that A, claims for mean profit or arrears of rent in respect of the property claimed or any part thereof. Now, you see, in case of mean profit, these profits are unascertained, not liquidated. There is no exact figure. The exact figure will be ascertained by the court through a proper procedure. Okay. Now, in this case, this is an unascertained claim, but this is the exception of the general rule that in the case of recovery of immovable property, only certain claims to be joined. This is the general rule. In case of immovable property, only certain claims to be joined. That means the uncertain claims will not to be joined or will not allowed to be joined, but There is exception. The first exception is mean profit or arrears of rent in respect of the property claimed or any part thereof. These uncertain claims may be joined with the recovery of immovable property. Now, second exception B, the claim for damages for breach of any contract under which the property or any part thereof is held. Now, if there is a breach of contract and that contract is regarding or involving that particular immovable property, then that claim can also be joined, irrespective of the fact that the claim or the amount of damages is unascertained. But till for the removal, I mean the recovery of immovable property, in the suit of removal of immovable recovery of immovable property, it can be joined. And the third one is claims in which the relief sought is based on the same cause of action. And the third one says, if the relief sought is based on the same cause of action, it can be joined with the or in a suit for the recovery of immovable property. In these three exceptional cases, only the unascertained or uncertain claims can be joined with the recovery of immovable property. Otherwise, the general rule is that when the suit is for the recovery of immovable property, only certain claims to be joined. Uncertain claim cannot be joined. Okay. Now, if there is a proviso says that nothing in this rule shall be deemed to prevent any party in a suit for foreclosure or redemption from asking to be put into possession of the mortgage property. Okay, so that nothing in this rule shall be deemed to prevent any party in any suit for foreclosure or redemption from asking to be put into possession of the mortgage property. Now, if any party asking to put him into the possession of the mortgage property, now in this rule cannot become an obstacle in that process. Okay. Now, rule 5 of order 2 says claim by or against executor, administrator or heir. What are the executor, administrator or heir? These are the intermediaries of your property. No, now the rule 5 says no claim by or agent, an executor, administrator or heir as such shall be joined with claims by or against him personally, unless the last mentioned claims are alleged to arise with reference to the estate in respect of which the plaintiff or defendant sues or is sued as executor, administrator, heir, or are such as was entitled to or liable for jointly with the deceased person whom he represents. So, in this case, says that the original owner or the original possessor of the property say cannot be in a suit against the original person or the original property holder, the owner of the property. His I mean legal claims of his legal heirs, executor, it cannot be cannot be joined. Okay, so no claim by or against an executor, administrator or heir. These are the persons against whom no claim can be raised as such shall be joined with claims by or against him personally, unless if these are his personal claim cannot be joined with the state. If these persons have personal claims or personal capacity claims, cannot be joined with the state. But if those transaction or connections or claims are transacted or related with the estate of the deceased person, or he is personally liable with the deceased, in that case it can be joined. Okay. Now 6 says order 2 rule 6 says power of court to separate trials. Now, where it appears to the court that joinder of cause of action in one suit may embarrass or delay the trial or is otherwise inconvenient, the court may order separate trials to make such other order as may be expedient in the interest of the justice. Now, in this case where we have just read that joinder of cause of action rule 3, now coming to the joinder of uncertain claims in case of recovery of immovable property. Now we just read that claims by or against executor or administrator rule 345. In these cases, if the court I'm sorry, if the honorable court thinks or it appears before the honorable court that the joinder of cause of action in one suit may embarrass or delay the trial, or it makes so complicated that final adjudication of the suit will be far reaching object, if that is the scenario, now in that case the court may may what is the court may order separate trials or make such other order as may be expedient in the interest of the justice. Okay, now I am requesting you everyone who are following these videos, please keep your barrack with yourself. If the video screen is not specifically or clearly seen by you, then please keep your barrack. I am always referring the order number, the rule number, the sub rule number, the clauses, always separately indicating each and every time. So please keep your barrack with you and just read with me, and that will suffice. In law we say that reading barrack is the most important thing. Okay, that's why our professors we always said us that it is where the law is, that is the important thing, where the law is, not what the law is. Because if you know where the law is, you will eventually or inevitably know what the law is. Or you may have to just have to spend a few minutes to find where the law is, and then you can simply read that. But if you don't know where the law is, you never know what the law is. Okay, so that's why keep your barrack with yourself. Now, rule 7, that is the last rule of I'm sorry, order 2. Order 2, rule 7 says objection as to misjoinder. Now, all objection on the grounds of misjoinder of cause of action shall be taken at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement of issues, unless the grounds of objection has subsequently arisen, and any such objection so taken shall be deemed to have been not so taken. Okay, any such objection to so taken shall be deemed to have been waived. Okay, now this rule says, simple in simple terms, this rule says if anyone have any objection regarding misjoinder of cause of action and this kind of in order one we have also read the misjoinder or non-joinder of parties. There is the same language is provided there also. Okay, that is order 1 rule 9. Okay, now in this case a cause of action, when it comes to cause of action, that is under order 2 frame of suits. Now in this case the rule is simple, that you have to raise your objection at the earliest possible opportunity and where the issues are settled in a proceeding before the settlement of issues. And if the circumstances are such that the cause of action as to I mean the objection as to the I'm sorry. Okay, now we are discussing about the last rule, that is object as to misjoinder. So, in case of misjoinder of cause of action, the objection must be raised at the earliest possible opportunity, and where the issues are settled, must be raised before the settlement of issues. And if the circumstances are such that the objection as to the misjoinder of cause of action arises at a later stage of the proceeding, then when the cause of action arises, at that moment the party can raise that objection. Otherwise, he have to raise it at the earliest possible opportunity. Okay, so this is order 2 of the civil procedure code.